Hello, everyone. It is April 10th and another session of the Dover Board of Appeals. Um, the meeting is being conducted with Zoom, and it is being recorded. The first thing we need to do is have a roll call of the board members present. Would you please start? And is Laverne here?
I am, but my picture's not coming up. Can you hear me?
Well, let's see. Have you hit the little camera down on, usually it's the left-hand screen?
Well, let me see.
There you are. Okay, we got you.
Am I on?
Yes, that's
Okay. It says
Okay.
continue.
good.
Oh, okay. There you go. I've got a new iPad, and so there's different buttons all over the place. Okay. So Laverne Lovell here. I'll start my roll call.
All right. Nadir,
Nadir Ahmed, member here.
Nancy Green, associate here.
Mike, Mike, you're muted, I think.
Mike Donovan here.
Hey, great. And George Schimento here. Good. And this meeting is, the primary purpose is to have to continue the public hearing on the application of Tom and Christine here, relates to their property on Dover Assessors Map 6, Parcel 103, address of 15 Park Avenue. And number one, a determination whether the lot is a corner lot, i.e. a lot abutting more than one street, as defined in our Dover bylaw 185-23. And next, the required setbacks for construction and relocation of accessory buildings. The hearers are appealing the determination of the Dover building inspector that the lot is a corner lot and is accordingly subject to setback requirements for a corner lot. Now, we have here, we're really fortunate. I mean, this is almost like the Supreme Court. We have three good lawyers here who are going to present to us. And here's how I would like the session to proceed. First, we would have the attorney for the applicant, Vinnie O'Brien, present briefly, his position. And he has a very detailed memo he sent to the board. John Doherty, who represents Lisa Doherty of 11 Park, is also going to describe his legal position. And he also has two good legal papers he sent to us. Ben Dowling, who is new, represents John and Indira Gertler. He today, really appreciate this, Ben. You sent us some very helpful guidance also. So we'd like to have you present first. We have with us another attorney, Kristen Kagalas, who is town counsel for this matter and other matters for the Board of Appeals. Thank you, Kristen. And so after the attorneys have presented, we're then going to open this up to Board of Director questions first. And then after that, we have a number of citizens. And I apologize, at our first session here, that was meant to be an abbreviated session. We had just been through a fairly long and grueling session for another 40B project. And we did want to open up the hearing. And part of that is just timing. We needed to open it up for this. And but today we're going to have more time, and citizens will certainly have opportunity to comment. I may ask that you, just in consideration of everyone wanting to get home before midnight, that we keep presentations fairly short. This is, and I am I'm going to be a little editorial here. This happens in neighborhoods when one neighbor is requesting something that other neighbors oppose. Um, However our decision ends up, my great hope is that everyone continues to be good neighbors. Now, don't let this, I've noticed from some of the emails a bit of, you know, extra concern and I hope that we're going to do our best. Like any decision, some people are going to be happy or some with the decision, and there are appeal rights if that is the case and you feel strongly. But we're going to do our best. No favoritism, and this is not like town meeting where the number of hands that get raised win the day. That's not the case. We've been asked to really make a very serious legal decision, and I hope you will bear with us for that. I'd like to give a brief history of where we are, okay? January 8th, the planning board, under our bylaws, essentially approved the site for the proposed construction. They made that approval based on representations that there is no business being conducted there. They also did not opine on setbacks. Essentially, they left that to the building inspector. The building inspector on January 14th decided this is a corner lot bounded by 2 streets. And as such, the setback for this accessory building in an R zone, rather than being 7.5 feet, is 20 feet. That's the way our town bylaws and the zoning code work. 6 days later, the HERES filed an appeal, and that has come to us. And what we did, we advertised for a hearing on March 20th. We had the advertisement published on a timely basis twice, March 6th and March 13th. On the 20th, we had a somewhat abbreviated session, simply because of again, the time that was involved with a prior matter. But we voted to, continue to this session so that there would be more time and so that everyone would have a chance to comment. We've also had a site walk, and for me, this is the first time I've seen your lovely neighborhood. And we actually had a nice walk on Oakley between the paved part and right on down to the parking lot of the church. It was very helpful. We learned a bit about the neighborhood, people's concerns, and that's helpful to us. But no decisions were made based on that. That was just basically to get strangers to your neighborhood more familiar with you. So at this stage, I'd like to turn this over to Vinnie O'Brien, who is the attorney for the applicant. And Vinnie, would you please summarize your position?
Okay. Good evening, everybody. I did provide, and Attorney Doherty also provided a lengthy legal brief, which I hope was helpful and not too overwhelming.
And in fact, Vinnie, you know what? Let me just, one other thing. It was so helpful, everything that we've received. Normally, we have a website now, or a web page on the town website. And up until now, we've reserved that for 40B matters that get lots and lots of interest, where we actually have the documents available to all the public, which at this point, Chris has been on vacation away. He is our employee who is involved in that. And I think this has enough interest that I've asked Chris, and hopefully in the next day or two, to populate that section of our website with all of the legal briefs and the actual documents that have led us up to this, which I think will be helpful for everyone. I'm sorry for interrupting, Vinny. Please.
Oh, that's quite right. Yeah, I think I agree. I think one of the, putting this situation aside, I think one of the most difficult things for everyone on one of these applications is getting access to everything that's been filed. And if it's online, it makes it easy. In any event, we submitted information to the board, which we hoped was informative and not overwhelming. In essence, there were kind of two issues raised early on and just recently raised again by Attorney Dowling, was whether this board had jurisdiction. I believe the board has satisfied itself both with the case law presented and hopefully speaking to town council that they do in fact have jurisdiction. And the other issue is trying to determine whether this qualifies as a street in as required under both local and statutory law. It's a simple position. Our position is that the town of Dover never actually completed the acceptance of the street, which is a multi-part process. One of the absolute required elements is that the town has to in some manner acquire a right in the way. And Attorney Doherty tried to say that other situations the town may not have acquired that right. I'm not sure what ones he may be referring to, but the two specific ones that are sort of relative to us, one is Park Ave, which is intersects with the street, and that was in fact deeded to the town with release deeds. And the other one that was accepted at the same, two other ones that were accepted at the same time as this one was Donley Drive. And when Donley Drive subdivision was approved back in, I believe, 1988, the person who did the subdivision, Roger Warwick, actually granted an easement to the town in the road, so the town then had the right to accept that based upon that easement. More recently, probably the most recent that I can think of was Stagecoach Lane. That was a subdivision where the developer did not maintain the fee in the way. In that instance, what happens, as you've seen in both Attorney Doherty's letter and my letter, the derelict fee statute applies. And under the derelict fee statute, if the owner of the person who did the subdivision didn't retain the fee in the road, the owner is owned to the center of the way. So that is an element here to some degree. But in our circumstance, the town never acquired ownership. There was no conveyance, there was no easement, there was no taking. And that by statute, MGL Chapter 82, Section 24, has to happen within 120 days of the town meeting. So from a strictly legal perspective, it's not a street. From a common sense perspective, and as Voltaire and Mark Twain and Will Rogers said, and I use it all the time, common sense isn't very common. That's why we asked the board to take a site visit. That is not a street. It's not a way. It's not a public way. It's not a private way. Never has been. And based upon current rules and regulations of the subdivision rules in Dover, it never will be. There's no allowance for dead end streets. It doesn't have the right width. Doesn't have the right elevation. So my thought ultimately, I think, unfortunately, Kristen, this is going to fall on town council to determine whether the statute has been followed. Briefly, I'd just like to comment just briefly on Attorney Dowling's letter that I just received today. And he challenges the jurisdiction of the board, which again, I don't think is accurate. And he mentions that there is a path that walks through the woods, and the path actually starts on my client's property and then crosses over into this parcel. And he's defining that as an alley and somehow making that comply with the statute. Irrespective of whether it's an alley or not, we can go back and forth on the definition of an alley. It doesn't look or feel like an alley to me, but it's essentially irrelevant since the taking was never properly, the acceptance was never properly done. Attorney Dowling goes on to say that his clients have a right to formalize their lots, which are in the opposite side of this parcel from my client's property. Absolutely, they have the right to do that. I just don't think that's a topic that's relevant for this discussion. Those lots combined don't meet the half-acre zone, and they, by law, have merged, and they've created one pre-existing non-conforming lot. He certainly has the right to file with the planning board to do a subdivision. The approval not required statute would not apply because there's no road. He doesn't have sufficient frontage, and he doesn't have sufficient area. And if he were to get an A&R plan approved or a subdivision plan approved, he'd need a variance from the Zoning Board of Appeals, which it meets none of the requirements of a variance. There's no issue with shape, size, topography, or soil conditions. So, but he has an absolute right to pursue his rights on those lots, and that's fine. We don't really care. In essence, we believe that the town never properly acquired the ownership, which means they never properly accepted the street, which means under any definition, this parcel of land is not a public way or a private way. It never has been. And if a subdivision plan was filed, this would never become a public way. That's essentially our position. And again, I'm sure at some point town council will comment, because it's really kind of a strict legal question and interpretation of the statute.
Thank you, Vinny. May I, Chris Costello, are you still with us?
Yes.
Oh, great. Chris, there is something, Mike Donovan keeps, his picture keeps coming up, and I think it may be a setting that has the person making sounds, their picture comes up.
Mm-hmm.
Is there, I know there's something we could press to just have, to fix that somehow.
Yeah, well, Mike's muted, so I'm not seeing that.
Okay, I just muted him, so that maybe
Yeah.
that's, I just. keep
Yeah,
up.
so if it does that, if it's picking up mic sensitivity, you can just do that.
Okay, also, I see from the attendees, Ted Mosher and Sue, I'm not sure who, have hands raised. Yeah, what we're going to do, we're having the attorneys speak first. And then we'll have board members ask questions of the attorneys. And then everyone in attendance will have a good opportunity to speak if you feel your points haven't already been addressed.
George, just for the record, I believe I said at the time of our I mentioned Donnelly Drive was actually Draper. Donnelly Draper, I confused the two, but it was that.
Oh, okay.
Just for the record, I have the right street.
Thank you.
That's it.
Thank you. Okay. I think at this point, Mr. Doherty, would you like to speak?
Yeah, thanks, George. I appreciate it.
Sure.
Hey, everybody. Good evening. So I'll sort of follow, touch on a couple of Vinny's points. Just to be clear, I think the whole jurisdiction issue with respect to this board goes more to how we've gotten far afield in this discussion here, because the board is charged, as advertised, the board is charged with determining whether it's a street, and quote unquote street, capital S, within the four corners of the bylaw. And we've gotten far afield by talking about the buildability, the functionality, the adequacy of it, subdivision rules, which are clearly planning board jurisdiction, and Vinny would agree with that. So I don't think there's any intent to suggest that we're all wasting our time here because the Board of Appeal does not have the juice for this topic. Not mean to imply that at all. So that's the one issue there. But the issue is it a public or private way? And we know, is it open or dedicated to public use? So we've got within the four corners of the document, we have to figure this out. And the adequacy of the way, functionality, it's not relevant for this discussion. So is it a public way? So all of Oakley was accepted as a public way by town meeting vote in 1998. And it's not simply by virtue of a 1926 plan, but it was in 1998, the layout was presented by the town engineer. And that's, it's per the town administrator's letter to the clerk. So, this is of recent vintage. And under section 23 of chapter 40 of the bylaws, a public way is established when it's accepted by town meeting vote. And I acknowledge, Vinny is talking about section 24, to take title or, for the eminent domain. And in the statute is very, very clearly provides that that's necessary. And there's a lot of circumstances where that may be necessary. Now, Vinny has talked about recent subdivisions, and I agree. The dynamic with a subdivision is typically that the town wants to be damn sure that the developer is going to build the road to spec and is not going to, take the midnight train when times get tough. So, there could be collateral, a letter of credit that's exacted, or a covenant, a lien put on the property. But the developer wants to get out from underneath that. So the developer is motivated to deed its interest in the road to the town and then be gone. They sell out the lots, they get rich, and then they're gone. They don't have road liability. So in this particular case, the town accepted the Oakley in 1998 as a public way, but it had originally been developed, 80 years ago. So that party was not around. That developer was not around. So, there could be a number of reasons, how the if necessary works. I mean, it's quite possible for a road to become a public way by prescription, meaning that the town, it's been used by the public for a period of years. The town has maintained it. So that could have been their thinking here. But, very clearly, there are several roads in town that there's nothing recorded. Now, Vinny had provided a copy of a release deed with respect to Park Avenue, but that's not recorded. Same is true for Cross Street, for Hutton, for Burnham. I mean, it's just, there's this major inconsistency here. And so I don't think the town can have it both ways in that respect. So that's that. So that's with respect to it being a public way. So if you don't want to accept any of that, maybe that's a play on words with accept, but it can also be a private way. If we want to call it a private way because you don't think it's a public way, that also can meet the definition of street. And what I think has been overlooked, and hopefully some or all of you have appreciated in your site visit, is that, a portion of this stub, of this extension of Oakley, is paved, and the Gertlers don't use a helicopter to get to their garage. Like they drive over it. So, I don't think we can play fast and loose with that. And similarly, as far as sort of, town planning and the whole purpose of zoning is to, sort of manage and regulate open space. The Gertlers and all of us suffer the burden of having to comply with the front setback for the benefit of the open space enjoyed by our neighbors. And so if you allow a side yard setback to be put right in front of the Gertlers, the front of their property, and that's the way this is laid out. I mean, that's not fair to them from an open space standpoint. And, it goes to the value of their property and everything else.
John, thank you.
So actually, I'm sorry, George, a couple other things.
Sure,
I guess
please.
I'd also, there was some mention of the 2002 determination of the barn as being, they had obtained a building permit there. But I'm sure town council would agree that, it's well established in Massachusetts that there's no municipal estoppel, which means that, Walter Avalon is not bound by any prior decision of Tony Kalo. And frankly, Walter Avalon can, if he says something on Monday, he's not bound to follow it on Tuesday. So it's, that's just really not relevant to this at all.
It is only a marriage where something you said 20 years ago is precedent that is binding. But no, we all agree with that. That's each decision.
Yeah, and I guess it also, just other things, sort of ticking off other things in Vinny's letter, he's also expresses concern about unintended consequences with paper streets across town. And again, I would say that here there was a town meeting vote. I mean, this situation is just unique. It's uniquely different from those other situations for the reasons that I've mentioned. You've got the town meeting vote, and there's no doubt that the scope of the vote and the scope of the acceptance pertain to the entire length of Oakley. So, I think going to sort of this jurisdiction of the board, I think the related point is that, the board does not have the authority to discontinue Oakley. That we'd have to be back at town meeting again. And, if that's the way we want to go, that's the democratic process, and that's what should be done. So I yield to the chairman. Thank you.
Well, thank you. Those are great points. Ben Dowling, would you please speak to the meeting?
Sure. Thank you so much for having me tonight. I appreciate it.
And incidentally, you're a fairly accomplished guy in addition to practicing law. Don't you have a prestigious position in the government of North Attleboro?
Yeah. Well, okay. So I am the chairman of the North Attleboro Zoning Board of Appeals. It's interesting. It's very interesting to be in front of another zoning board of appeals, and it's a hard job. And so I will thank you, because you don't get thanks from a lot of people, I'm sure. Coincidentally, before I go, I have to mention that on Saturday morning, I am going to be in the Chickering field with my daughter in the snow as she faces off against some great Dover soccer team. So anyways, okay, sorry. Okay. Thank you for having me. I was working on this letter, and I was working hard to get it in today, and it was a kind of a rush job for me. And so after I emailed it off, I realized I maybe didn't express myself exactly the way that I wanted to in the letter. I came close, but then afterwards I said, oh wait, so this is what I'd like to do. I think that the core of my critique, okay, in number one, let me just state, I represent John and Indra Gertler at 14 Oakley, and we support the current building inspector's determination that that Oakley is a road, and so that the setback should be 20 feet. And here, the summary of my position here is really one of statutory scheme. Okay, in Massachusetts, when it comes to land use planning, there are two boards. There's the zoning board that does zoning; it's in the name, and then we have this other board called the planning board, which really does roads. That's what the planning board does. The zoning board does zoning. The planning board concerns itself with roads and ways, and it does that through the administration of subdivisions and approval not required plans. And so but you're, and I do believe that the zoning board, the Dover zoning board, have jurisdiction over this question, but I think you find yourself in a bit of a gray area, because you're sitting in the position of making a determination about whether Oakley Road is a street, which is normally something that the planning board does. What you happen to be doing is sitting in a position that's really most often a planning board is sitting in that position, making determinations about approval not required or about a subdivision. And so you are as the zoning board, in a way, you're sort of wearing a planning board hat in making this determination. And so I think that what's important for the zoning board here in making your determination and in making your decision is that you take into consideration appropriate factors. And the appropriate factors for the zoning board to take into consideration are matters of zoning. They are matters that are important to the zoning bylaw in the town of Dover. One of those things that's very important is something that John Doherty mentioned, which is everybody in town has to work with the setback requirements. And so you could, by making this decision, you could be placing, and I think you're well aware of this, I'm restating it and reminding you, just in case you're not, that if you make this decision to allow a 7.5 foot setback, you could be potentially creating a problem for the other side of the road in terms of not equally applying the setback standards. So anyway, you're in this gray area here. You're having to make a determination that is really a planning board determination, and so you should stick to principles of zoning. And I think there are two key pieces of information that you need to make this determination. One of them is that 1926 plan. The road was laid out in 1926. That's very clear. Nobody disputes that. And then the other one is that Oakley Road was accepted as a street by the town in 1998. And I think those are the only two facts that you should take into consideration. The site visit that you had, which I agree with Attorney O'Brien, is a common sense. That's a common sense activity and practice. However, in this particular case, you are making a legal determination. You're not making a common sense determination. And things like the adequacy of Oakley Road are very clearly, by statute and by case law, those are considerations that planning boards take into account when they make their determinations about what constitutes a road and what doesn't constitute a road. And so I'm not saying that the zoning board doesn't have jurisdiction. What I'm saying is that the zoning board should be careful to rely on appropriate factors to make its decision. And those appropriate factors here are factors that have to do with zoning. With regard to the possibility of 14 Oakley, otherwise known as lots 7 and 8, at some point in the future, formalizing themselves as separate standalone lots. I do think that course of action is it's a long shot type course of action. However, it's not impossible. It's not an impossibility. There are avenues by which that could occur, and if it were to occur, and the garage that's proposed at 15 Park Avenue is allowed to be constructed within the front yard setback, you will have essentially created a situation where on one side of the street, one set of rules applies, and then on the other side of the street, a different set of rules apply. And it's a little presumptuous, I think, although I just acknowledge that it's a long shot, it's a little presumptuous to put yourselves in the position of forecasting what the planning board may do if they receive a subdivision plan or an approval not required plan. And then I also think it's a little presumptuous although you are the zoning board, you know how you would vote if you were faced or if you received a variance request, which my understanding in Dover is that they might be a little hard to come by. And so, but with that being the case, no variance request is before you now. So you're presumptuous to even think about that scenario, if that makes any sense. So I think that summarizes my position. Again, thanks for having me. And
Well, Ben, it's great. Thank you very much.
George, may I just make three quick
Yes.
little points, but just for the record, just to clarify things. The Park Avenue conveyance to the town was in fact recorded. It's recorded in land court. The docket number is 216321. And Attorney Dowling is correct that roads are created by the planning board. But I had provided to the town, to the board, a case that we should probably share with Attorney Dowling, Shea versus Lexington. In that particular instance, there was an A&R plan that was approved by the planning board. The road wasn't constructed similar to this road, and the zoning board of appeals was the jurisdictional authority. Different situation, but jurisdictionally, that's correct. And also a really interesting case that has been involved for many, many years and many different issues is the Origo case that Attorney Dowling cites. And that also says there's two different hats being worn. In no way, shape, or form are we requesting that the zoning board of appeals take on the parameters or duties of the planning board. We're just requesting that you follow the statutory guidelines. That's it. I just want to clarify a couple of those factual issues.
Well, that's good. I think thank you, all three of you. And again, your memoranda will be on the town, the town website, hopefully within a few days. Chris is just back and everyone can really enjoy reading some, at least, well, I don't know, some people don't like to read what you lawyers write, but it was helpful to us. I think this next session, a part of the session, is going to be board questions. And I'm going to, it's not just because I'm the oldest, I am the chairman. So if my board doesn't mind too much, I'd like to start off. And a lot of these questions are going to be addressed to Vinnie O'Brien. Vinnie, I'll be frank. I am very troubled with the theory that this board could essentially nullify town meeting vote, at least from what I see so far. Certainly that vote said that to the extent necessary, or if it were necessary, the town should go on to actually acquire title, which it actually did in the case of Park Avenue and other streets. And of course, you're the dean of these things in town in many ways, the records. I mean, the attached to your brief are great records of the town doing this. But I wonder that, in fact, a town, when is it necessary? A town essentially gets a right through this town meeting vote. They don't own the street, but they certainly have some sort of ownership right, prescription right, easement right, whatever the correct term is, simply because the citizens of the town of Dover looked at a map. There was no distinction, this part's stub, this part is not. The town said, this is something for the town, and town, you can acquire this land if you want. Now, for example, if you were, say, wanting to put in sewers or other things, you would definitely want title in a case like that. But here, essentially, whether it's a road just for traffic or, it's interesting because our town does look to the Merriam-Webster dictionary, 11th edition, not the Oxford dictionary, the Merriam-Webster dictionary. And, I wonder, the definition of public way or street is essentially any passageway open as of right to the public and designed for travel by vehicle, on foot, or in manner limited by statute. Now, I'm not saying that every footpath in Dover becomes a public way, but there is no question that, and this is where, see, I thought the site visit was very helpful to actually see that land, and it's a well-traveled path, and it's laid out just like the paved portion of Oakley. And so I'm wondering, what authority do we have to say, essentially, are you saying that we would say that is not a street anymore? And if it's not a street, has the town of Dover lost all of its rights in that piece of land with that determination? I question whether we have that authority. That seems to be something that town meeting should decide. At least that's my view. And believe me, this is because we don't caucus on the side. So I have no idea how my fellow members of the board are going to think, and we will find out. But I am really troubled by the idea that we can essentially nullify the town meeting vote. And if we do that, it does seem pretty clear that that portion of Oakley then is owned by the owners on each side of it up to the middle. And if the town doesn't have rights on it anymore, and if it's not a public way, essentially, do they have the right just to stick up a fence, divide it, and deal with it as their land? And it seems that's the ultimate conclusion if we go against what the town meeting decided. So that is one thing that really does trouble me. I think also. Oh gosh,
George,
I don't want to overdo this. The Shea versus Lexington. Oh yes, go ahead. I mean,
just related to that point. I guess one of the things that's just troubling me a bit is how do we take the position that we're going to treat part of Oakley different than another part, right? Like so I recognize that they look very different, but they seem to be treated in sort of the town vote kind of as a single thing.
mm-hmm.
And then we, in making any sort of decision that sort of changes that view, is we are sort of defining a part of that road differently or part of that street differently than the rest of it, right? And I'm assuming that the city maintains kind of the rest of the town maintains the rest of Oakley when it comes to like snow removal, other things, or maybe that's an open question to be answered.
Mm-hmm. Actually, let me ask other board members here, and I may have to unmute you. Let's see here.
George, you want me to wait for all the board members, or do you want me to respond to you?
Oh yeah, please, Betty. Yes, go ahead.
So, just to respond to Ahmed's question, we are not suggesting that they be treated differently, and I'm certainly not suggesting you're nullifying the town meeting. The town meeting specifically voted in the meeting to acquire such land by purchase or otherwise. That's the vote. It was never perfected. So you're not nullifying the vote. You're just saying it never happened. And the question of necessity.
Let's, in fact, I've got a copy of that. Let's bear with me. I'm going to get that.
Yeah, and related to that is necessity. The only time it is not necessary that the town acquire the land by purchase or otherwise is when the town already owns the land. If they don't already own it, they have to acquire it in some manner. And if the neighbors or landowners won't convey it, they have the right to take it by a actual taking, an eminent domain taking. And what's interesting about Oakley, which is an interesting circumstance, easement by prescription does not apply. You cannot obtain easement by prescription on land court property.
Say that again.
You've heard the term adverse possession
Yes.
or easement by prescription, which means if you use something openly, continuously, notoriously for a term of years, specifically 20 years,
Right.
you gain a right or ownership of that land. Or if you use a pathway, for example, openly, notoriously, and continuously for 20 years, you get an easement by prescription. That does not apply to land court property. You cannot acquire land court property by prescription. You cannot acquire land court property by adverse possession, which makes this situation even more complicated. But again, the town has never, you're not nullifying the vote. You're just saying that it was never perfected. And it doesn't mean the town can't do it again and do it right this time, but it's not right now. And typically with derelict fee statute, it sounds weird, but typically what happens is the owners own to the center of the road, but the setback for sideline is interpreted as of from the lot line. So we're not asking 7 feet from the center of the road. We're asking 7.5 feet from the sideline. Just want to be clear on that.
Okay. Let's, other board members. Okay, Laverne. Just a sec. In fact, I believe are you muted, Laverne?
You're still muted.
Yeah, I think Laverne, you've muted yourself, I believe.
Yeah, we got it. Okay. So I have a different perspective, obviously, than everybody else because I'm not a lawyer. It seems like this is a corner lot to me, and that perhaps they do have to do the 20-foot setback. And I think for many reasons, it would be better. It's a 3-car garage, a 1.5 stories tall. It's going to make a very big impact on the whole neighborhood. Coming around the corner, you're going to see that big garage there. So I think sort of nestling it in, maybe down a little bit further and over, and in my estimation, it is a corner lot. So that's. I also have one more comment. Does the building inspector ever send the applicant back to the planning board for a hearing? Or they always come to the Board of Appeals? Because if everybody's saying this could be a planning board issue, just a thought.
Well, I think there, the emails I've received from a number of neighbors, but I try not to discuss substance by email.
Right, with them, right. Well, that's just kind of my comments, because I don't know the legality of the whole thing.
Well, I think there is a great deal of unhappiness with the outcome of the planning board site approval process.
Oh,
I don't think that the process is much, but essentially, and they've been very careful. I believe they devoted 2 sessions and several hours, and it's certainly not up to us to review that again. But that was a critical part for the hearers to then submit their plan to the building inspector.
right.
And the building inspector then made the decision that this is a street on a subdivision plan accepted by the town, and that the setback should be 20 feet.
I could also just,
Well,
George,
I
if it's,
agree.
or Laverne, if it's helpful, the question of the setback is a zoning question. So when the building inspector made a determination on that, that question comes to the zoning board. In general, as you know, the planning board does deal with issues having to do with streets, but here where the question was, what is the applicable setback? That's why it went to the building inspector, and then his determination is appealed to the zoning board.
Very good. Thank you.
That's good. Okay, are there any other board? Let me just see. I just want to check one thing.
Laverne, just quickly, by the
Yes.
way, from time to time, I've seen applications denied for one particular reason or another, and sometimes it's due to the area or something along those lines, and people do go back to the planning board to re-subdivide the property. So from time to time, that does happen, just so you know.
Okay.
Yeah.
Thank you. Thank
Yeah.
you.
Vinny, I'd like to speak with you again about the Shea versus Lexington case, which was very important for your memorandum. That's the one where essentially the court felt that if a fire truck can't drive on it, it's not a street.
That's right. Correct.
But that decision was based on it's not a street for purposes of proving that your house will have access to a street. So you can't have a house if there's essentially only paper access.
Correct.
But that decision did not really involve this type of situation, which is setbacks. And so I wonder if there are any cases that essentially would deal with this setback issue that we have. I think there's no, at least in my naive mind, I don't think there's any question from a frontage point of view that with that sort of path with the trees, well, you'd have to do something to be able to call that a street where you have access, because you have to have frontage on a street. But here we're talking about setbacks, and essentially this setback is something that impacts really the entire neighborhood. Everyone has bought here with a plan, with certain setbacks, and that includes this undeveloped portion of Oakley. I wonder if there were some case law dealing not with direct access, which is what the Shea versus Lexington case is, but something that would say that once you're a paper street, then the lots on it have no setback requirements at all.
Oh, they still have setback requirements. It's just a question of what is that area next to that particular lot. So if that area next to that particular lot is owned by the two landowners as the direct fee statute, they own to the center, but they still use the setback.
Yeah.
The sideline. So, and I think what they're saying is basically what the case Attorney Dowley made reference to. A planning board can say where a street's going to go, or if it's potentially going to be a street. It's the Zoning Board of Appeals decision to determine whether in fact it is a street.
That's right. Yes.
So, in that particular case, on both ends of the street, it was a street. In this particular instance, it's just like this piece of property. It's not paved. It is not a street. In this particular instance, it cannot become a street because you can't have a dead end street in Dover. So that's the only reason that case is cited. But your first question to me early on was jurisdictional. This showed this is clearly a jurisdictional authority that you have. And, as such, and by the way, this way creates a 40-foot separation between the lots. So from this, correct? So
Yes.
From the center of the lot, he has 27.5 feet. So there is a separation between these lots. That is more than all the other lots on the street. Because all the other lots in the street with sideline setbacks only 7.5 feet. So they're only 15 feet apart.
Well,
Here we have.
Is it your position then that the town, because it did not buy this property, that the town has no rights whatsoever?
No, a town has the right to plow a street, even if it's not publicly owned. They have the right to maintain it if they wish. They typically don't. But the town has not properly accepted the street as a public way. And Part of the reason is
How does that analysis apply to the paved portion of Oakley?
they didn't accept that either.
So essentially, is the town now supposed to acquire title to all of Oakley by going to each of the neighbors that are?
Well, typically, I would imagine that that's what the neighbors would like. And I think that's what the neighbors thought happened several years ago. And in a town meeting, that's typically what would happen. And prior to the town meeting, as they did with Stagecoach, they would approach the individual landowners, and Kristen can, kind of confirm this for the board on the side. Typically, what they ask from the neighbors is a couple of things. We want a waiver of damages that you're not going to sue us for anything. The neighbors deed the property to the town, and then it's already been laid out, correct? We know the property's laid out. And then either prior to the town meeting or within 120 days after the town meeting, those conveyances have to take place. That's statutory. That's not willy-nilly. That's not loosey-goosey.
And I read that more as when the town is creating a street. This street already existed because of the subdivision plan. I mean, I really question that you actually need to have title in a case where it is laid out prior to the subdivision law, and where it's accepted by the town, essentially saying, yes, we'll have the obligation to maintain it. But I'm just very, very reluctant to reverse a town meeting vote in these circumstances, which is essentially what we do. It'd be different if the town decided, yeah, we're going to build a road, and it gets built, and then for some reason doesn't acquire title. That's where I would see the statute with, I think, what the 120 days to perfect or whatever it is would apply. But this
Again, I can only rely.
Set out, it was recorded, all prior to any zoning, any planning board jurisdiction, and the town has accepted it. Town didn't create it.
That's the question. Did they accept it? They have not completed the acceptance. And again,
yeah,
I would defer to town council only because, unlike me, they're objective.
I'm trying to be also.
Oh, no, I agree.
But I just I look at town meeting as sacred in many ways, and if it's going to undo something, I believe that's the proper form for this. But that's my view, and what we're going to have to do is run up some stiff, not too stiff a legal bill, please, Kristen, but yeah, I think here, again, the concern, and and it really is this legality, and that really, I think, is we're not second guessing the site plan. We're not questioning whether there is a business or not. Those are all separate. And in fact, even to address those would pollute the actual, I think, decision we come to. This is strictly a decision about setbacks.
It's a narrow decision. And I'm not suggesting it's easy, but it's a narrow decision. And
that's right. Okay. I think
George, I'm sorry to interrupt, if I just might add the 120 day period that's in that section 24.
Yes.
That also is a scenario that I think you're alluding to, where there's a clock on it because the town has appropriated money. There may be an appraisal. There's probably an appraisal. So they have to deal with it within that 120 day period. So here, I think it applies even less for the reasons that you mentioned. Right. So if you're going to write a check to someone because you're going to run a road through their field, the town has to appropriate the money and they want to, you know, that's to be dealt with within the 120-day period.
Yes. Okay. Now, let me see. I'm going to start. If the board is content at this stage, let me see if I can hit the right buttons to would everyone in the audience who's not on the panel, who wants to speak, would you raise your digital hands, please? And I'll invite you to the panel so that you can speak. Okay, and I see Heidi Handler is the only one. Let me see who else. No, I think Heidi Handler is the only one who has raised a hand so far. So Heidi, let me fight, and let's see if you can. There you go.
I unmuted. Is that,
Yes,
if that's possible?
go ahead. The floor is yours.
Thank you. And thank you. I believe I did send a comment and I did thank you for your service. I know it's not an easy job. I know running a public hearing is not easy, so I appreciate that.
Oh, the pay and benefits are wonderful, so don't worry.
Yeah, I'm sure they are. What I had a few points. The first is that, and it does appear that you take this seriously, but the Zoning Board of Appeals is the steward for the town. The town at town meeting has expressed exactly what they wanted done with that property. I share your concern with regard to undoing that. I leave it to the people who briefed this to make the legal arguments regarding whether or not that is a street or a road. But part of what I said in my comment is that if for some reason the town were to find that were not a road, I think as the stewards of the town, it is incumbent upon the Zoning Board of Appeals to not issue a permit or not permit any building to continue until such time as town meeting gets to make a vote again. So I don't think it ends right where you've said. I mean, I think it should end, and that I think based upon what I've heard, that it is a quite clear, succinct issue, but I don't believe that is the end of the issue.
Heidi, one thing, see, statutorily, when there's been a building inspector denial and an appeal is filed, we have 100 days to come to a decision. I have actually, thinking we need more time, I have sent to Vinnie O'Brien today a request that we extend for several weeks that 100-day deadline. I've not heard back. Vinnie obviously has to deal with his clients on this.
I haven't talked to Tom about that yet. We'll get back to you on that though, Judge.
Thanks very much. It gives us time, but we will, Heidi, we will have to come to a decision. And I don't think it's either going to be a yes or a no. It can't be, we're going to pause it until town meeting addresses if we think it's negative. I don't think that would be permissible. And of course, if we don't do this correctly, the matter then defaults to what the appellant has filed his appeal for. So I think there's a lot of common sense in what you say, but I don't think we can do that without jeopardizing the decision.
I haven't briefed that issue. What I'm saying is you are the town stewards. One of the problems, and I know you don't want to go into other areas, and I'm not going to necessarily speak about them. They were in my public comment. The planning board did not address all of the issues that were raised. The planning board process they said they had no power to make those decisions. Somebody has to have the power to make those decisions.
Okay,
This is a process issue.
Be more specific about what particular issues are these the use of the property?
These were, the planning board said that they had no power to deny the permit unless they left it up to the building inspector. If it met the requirements of permeability and setbacks, they had no power. I don't understand how they are a planning board with no power. It befuddled me at the time. The chairman of the planning board said it multiple times during the hearing that they had no power to deny it. I think the whole purpose of a planning board is to plan, if the planning board had addressed all of the issues that the neighbors have concerns about, we would still have this issue before you, but there may not be so much uneasiness. For example, the planning board.
Excuse me, Heidi. Again, I hear dissatisfaction with the planning board management of the issue. I don't know if there have been any appeals filed for that or what, but that is not before us. If we bring that concern into this decision, and if the board were to decide, let's say the board decides to deny the appeal, but if we have in the process of that decision taken into account concerns that the planning board didn't do its job right, I think then we don't have a very good decision if it is appealed to a court who's going to say, you didn't look at the right stuff. You should have just had this narrow focus. Your issue was the setback. It was not to second guess the planning board. So I hear you. I don't know what the rights are if a person is unhappy with a site approval decision. This one was made, I think, January 8th. To my knowledge, there's not been any appeal filed or anything. There's just dissatisfaction. And it just, I am afraid, unless our counsel advised otherwise, I don't think we can offload that issue to the ZBA for this particular situation. Kristen, would you, and I'm not asking for a definitive legal opinion, of course, but am I correct? We should be narrowing our focus strictly on the issue of setbacks.
Yeah, that's exactly correct. The issue is the building inspector's determination in relation to setbacks here. It is not a broader. I understand there's greater frustrations, but the issue in front of the board here is very narrow.
If I may continue, what I was saying is that the building inspector chose to make a determination on one ground and did not make a determination on other grounds. And my point was that if the decision of the building inspector is found to be incorrect, it should be remanded for the building inspector to make a determination on all grounds that the planning board asked it to decide on. It only chose one, the building inspector only chose one ground on which to deny the permit. There were many possible ones. That's what I'm saying. Secondly, to answer your questions, the town did pave Oakley Road. My property border is on Oakley Road. It goes from Park to Oakley. When we moved into our property in 1996, Oakley was not a paved road. It was paved since we've been here after the town meeting vote. So that was just a question that I believe Ahmed, a member of the town, of the committee, or the board had. So I was answering that for you. I believe that I have indicated my other concerns in the comment that I submitted, and to echo what one of the members said in terms of common sense approach, that people walk through that area every single day, to walk dogs. It is heavily traveled. There are paths that go all the way to Chickering School from there. It is a well-traveled area, and I defer to others who have briefed the issue. I've put all my comments in writing already.
Yes, and essentially, I had that concern as well, and I believe Laverne Lovell raised it as well. Under the dictionary that we look at, a Webster version 11, it does talk about passageways that are open for foot traffic. And it's who is to know? And again, my thought, my reluctance to discard what I think is a fact that this is a corner lot. We don't really know what will happen with that property in the future. Will it be paved? Will there be an acquisition maybe of land that is presently part of the parking lot for the church? I don't know that the parking lot ever gets full occupancy these days. So yeah, there are just lots of things I feel, but we're not. This is me at this point. I think I'm getting a sense that Laverne and Nadir and Nancy, although Nancy and Mike, you're not voting members, but you do stand in case one of the voting members isn't around to vote. And your opinions count just as much anyway. Have you given some thought to this? What are your thoughts?
George, I think I'd like to turn this over to the people who have come onto the call and just hear their comments, their further comments before I summarize what I'm thinking. Excellent. And also then at some point, I think we need counsel too. I'd love to see the extension, quite frankly. Yeah, but I'd like to hear from other people.
By the way, just to answer George's question and Nancy's, I was able to text my client and we agreed to the extension. I was not able to reach him during the day. So George, that extension went, I'll get it over to you tomorrow.
Well, thanks very much, Finn. Okay, let's and Mike, unless you want to speak now, I'll go back to the citizens. I see Ted Mosher has his hand up, and Ted, let me allow you to, and then Heidi, I'm going to mute you for now. I mean, just so that we, if I can hit all the right buttons here. Okay, I think, there you go. I think you're all set. Okay, Ted. Okay, and
George.
Yes, okay, gotcha.
Thank you very much. Ted Mosher, 6 Oakley Road. So I fully appreciate, first of all, I appreciate the position you guys are all in, and thank you for doing it. And I agree with you that you're trying to limit the scope to a setback. But I think that what appears to me, or at least as I understand it, which may be wrong, is that while we are limiting the scope to the setback, apparently the scope has been broadened to what is the road, and based on what the road is what the setback is. And so I think in order to get to limiting us to a setback, we have to come to terms with what is the road. And I think we're kind of all under the impression that this road belongs to the town and that they took it. And whether or not they did it correctly or so forth, I think that needs to be determined, because if we don't know what this, we don't know what this.
I think this is a matter of title. It is not owned by the town. That was actually our initial thought. But it is under this derelict fee statute. It's actually owned by the lots that are across from each other on it, up to the middle. And the town's right, I think, is whether you would call it easement, prescription, and I understand this is land court land, but there is some type of right that the town most likely has, in my view. So I think here, what we're really getting down to is, for purposes of a setback, is this in its present condition with the fact of town meeting acceptance? Is it a street? In other words, is this a corner lot? Or is it just basically raw land, which would then mean the setback is 7.5 rather than 20.
And for the record, we use that pathway, and we have for years used it to access the church.
And that is very important in my view. I mean, again, I don't think any of us were at that town meeting when Oakley was accepted.
I was there.
Except for, yeah, we're okay. But I'm sure there was no discussion. Yeah, part of this is paved, and part of it's not. And, it was a piece of land that the town wanted, and for current or future purposes. But the vote accepted the whole thing, and the town was to acquire title, I guess, if it was necessary.
Yeah, and I think that's where the semantics come in, but
Yeah.
and you guys have the unfortunate task of sorting out the semantics, but thank you.
Okay, Ted, you bet. Thank you. And I see now, Ted, I'll mute you, and Deborah Harrison has her hand up. Deborah, here you go.
Thank you very much, and thank you for taking this on. I think that there are a number of things that have to be figured out to be able to move forward on this. And I live at 10 Oakley Road, and I walk on that path just about every day too.
Yeah.
My question is, what happens to the finished off part of Oakley Road? Depending on what this gets decided on this pathway type thing, is the Oakley Road likely to be not plowed anymore, not have repairs done to it, get cut off, get renamed, whatever.
Well, we have actually other roads that have been accepted, but where the town has not acquired title, where the town, in fact, services them as if they are public roads. In fact, we presently are dealing with that with a road, Tisdale Drive, where there was no formal purchase or acceptance by the town, just a vote. And that's actually a matter for which there is an awful lot of contention. It's, again, we've got counsel, and
Yeah.
she will do her best to advise us what is right. We are stewards for the town, but we are also stewards for people who own their land. It is not government always first. If people have rights, it's our duty to protect those rights. And indirectly, that does protect the town.
Yeah. Well, good luck as you straighten all this out, because I think it's a Pandora's box.
Well, listen, thank you very much.
Thank you.
And let's see here. Actually, I love your neighborhood now that I've been there. It's nice. Okay, does anyone else have their hand up?
Indra and John do.
Okay,
Yeah.
see. Okay, hold it. Wait a minute, just a sec now. Deborah Harrison.
There they are. That's them. You got it, George.
Okay. Oh, okay, they're on the panelists. Okay, yeah, okay. Just a sec. Now,
George, can you hear us?
yes, we can. Hi.
Okay.
It's good to meet
John
you.
Gertler. Indra and I live at 14 Oakley Road. We have been there since 1986. When we purchased our property, everything that from the plot, the land court plot here to our mortgage plot that was given to us, to our deed, which says we own 186 feet of frontage on Oakley Road. That we have the two lots that run down this extended part, and we join the Most Precious Blood Church, and we have frontage on both, all that distance. That's what the deeds say. That's what the plot, this plan says for, 1926. That's what every Dover tax map or anything I've ever seen, or what the town, when they acquired this, says is there is a roadway there, and that's something when our house was built in the 1940s, I think the late 40s, they decided to put the house mostly on our lot 7, and our garage and driveway are over into lot 8. And when they constructed that, this so-called stub going down was opened up for about 40 feet to allow us access, or not us, but the owners access to their driveway. Without it, as I think John Doherty said, we'd have to have a helicopter to get into our drive. So that's been there since the late 1940s. When the town acquired by a town meeting in the late 90s, right after that, the town paved the road. It had been unpaved up until then. When the town paved the road, they paved the road and they took it down past the corner of Park into our driveway. When the town did that, they did not expand the road. They didn't bring it up to code. They simply paved it and left all the hills and such that are in Oakley Road, but it was paved. The town plows the road.
John, I missed this in our sidewalk. Your driveway, is it
Our driveway
actually go into this stub part?
Yes, you have about 40 feet in to the far edge of our driveway from this stub. And there's another about 4 or 5 feet that's not paved, but it's flat, and you could, park a car there. You could put Mr. O'Brien's fire truck from the edge of that in, or at least about 40 some feet of it, and park it there.
Past Park Street.
Past Park Street, past the edge of Park Street.
Okay, so that the stub, because your driveway is going into something you can drive on.
Oh, absolutely.
So the unpaved stub is from the edge of your driveway to where you go to precious.
to most precious blood.
And so now, assuming whether that's paved or not, it's certainly you've got access to your driveway. Is any portion of that
53 feet unpaved.
part of, I mean, does it, if you just drew a line across, does that go to the Here's property?
If we drew a line across from the edge of our driveway, most closest to Most Precious Blood Church, it would go right into the proposed building. I would like to.
Oh my goodness, okay.
So that's been there.
I'm sorry, that is just not true. Jeez Louise.
We have measured it, so have the Dohertys.
Okay. I think what we'll need to get a more precise delineation of that.
Okay.
Please let John continue.
Yeah,
Yes.
let me continue. As I said, there's no reason for us to have assumed that if we wish to build further on our property, that we would not have an access on the rest of Oakley Road, just as part of it was improved when our drive was built in the 40s. If we wish to put a bigger garage of our own, we would expect to be able to continue the improvements down the road. The fact that, they're saying this road couldn't possibly be put in because of the grade elevation or something, the width of it and the grade elevation are certainly no more extreme than the rest of Oakley Road. You could grade it from the edge of Park Street down to Most Precious Blood Church. That's going to be far less grade than the big hill at the top of Oakley Road. Going back to everybody's favorite, Shea versus the Board of Lexington Appeals, that was a matter of, the people asking for a building permit. And the decision right here says that they were correct, Lexington, in withholding the building permit for the plaintiff's lot so long as the road on which it fronts remains unconstructed. Not that it could never be, but it remains unconstructed. I contend that the rest of Oakley Road could be constructed. And I'd like to propose something, since it's been said that our lots are unbuildable. Nothing basically could be built on our lots, and because they don't have more than 100 foot of frontage. Of course, almost all of Oakley and Park have lots that are less than 100 feet. I believe the Dover Town Law says that when things that happened before 1980 something, provided they were on a plan that was submitted before the planning board and before that 1980 something, which certainly this 1926 plan was, it's a 40-foot frontage on it. 12 Oakley Road, right next to us, about a little less than a year ago, the house was sold, a developer bought it, the house was leveled. A gigantic, this is a lot half the size of ours, so one lot where we have two. The gigantic house was built on that. I believe the setbacks not being quite 20 foot is something that came to this board's attention a little while ago because they had their porch or something not quite 20 foot back. But anyhow, the town planning board, zoning, everyone allowed this gigantic house to be built on a single lot. What I would propose is, when Indra and I decide to sell this house, the way things are going, it's not going to be somebody wants a little old cape like ours. We have two lots, a little less than a half acre. Somebody's going to buy it. I don't think they're going to try to have two separate lots. As we said, that's a long shot. But what they're going to want to do is put a very, very big, expensive house on those two lots. I think they would probably much bigger house than ours and spread it out much closer to Most Precious Blood's parking lot in from that, facing out onto Oakley Road. And I assure
is
you,
ruined.
when I assure you that road can be improved. I also seen in town bylaws of roads of what it takes to improve. You know, as I said, Oakley doesn't meet the new standards, but they're looking at what the roads, purpose of the roads and use would be in traffic use. Obviously, this stub is for access to one or possibly two driveways. The access would be to 14 Oakley Road or 15 Park. That's the only traffic that would go down there. When these new owners.
May
Yes?
I interrupt you for a minute? I want to ask Vinnie O'Brien a very important question, at least important to me. Let's say that the town had not voted to accept the road. It seems to me that vote essentially legitimized from a budget purpose the town spending money to maintain it. If that vote had not taken place, wouldn't it be likely the town still would have serviced? I mean, is that vote and whether title was acquired, is that really that important when we have a recorded plan which shows this as a public way?
Absolutely. So the town has, there's several ways in town that the town plows.
Yes,
They don't own and have not accepted as public ways.
that's right.
And statutorily, they can do that. And they can also choose to maintain if they wish. Typically, they don't. So I believe Turtle Way, many years ago, all the neighbors chipped in to have it repaved because the town wouldn't. So there are, you know, the town has the right to do that, but that doesn't acquire ownership, and that does not perfect an imperfect acceptance.
Yes.
And, you know, the 40-foot statutory reference that's being referred to, that 40 feet has to be on a separate deed. These lots have merged. I don't really think it is relevant to our discussion. I think, you know, the point is, and it's not an easy question, I realize, is whether this is or is not a street. From a visual perspective, it's not, but really it boils down to not whether it's visual or not, or how it's used. The fact that it's people use it as a trail, there's hundreds of trails in Dover. That doesn't make them streets. The question is, was it statutorily properly accepted? And again, I think the best party to respond to that is probably town council.
Okay, thank you. And John, you may resume, please.
Okay, thank you. And I believe just the 40 feet issue is, I think it's say that if you look at that, you'll find out that it's 40 feet or a single light, a lot more. Anyhow, I think there's more to that. But let me get back to what I was trying to talk about. Because we have not worried about that. We have 186 feet. So we're not really worried about the 40 feet. As I said, I see someone wanting to build a very nice big house there. I'm almost positive that the planning board are going to look at that and they're not going to let them build this big house 7 feet off of Oakley Road. It's going to have a 20-foot setback. And when this big house is built and they look out their front door out across Oakley Road, they should look over to neighbors that have had to abide by a similar setback. And we certainly, as I said, we know from 12 Oakley Road, you just went through a setback issue when they weren't quite 20 feet back. And I think to have anything less is, and you know, just not fair.
John, thank you. That's very, very well said. Thank you.
May I say something?
Yeah, go ahead.
Well, I'll be very quick.
Sure.
What I'd like to bring up that hasn't been brought up is that the Hares attempted to buy the Oakley Road spur. They were told by the town selectmen, absolutely not. It is owned by the town. So if you say that our spur is not Oakley Road, not only will you be going against the town vote in 1988, but you'd be going against the town selectmen who only recently said the spur belongs to the town of Dover. So we should look that up. I don't know how to look that up, but the spur belongs to the town of Dover. We want it to belong to the town of Dover. We want to use it for future building for either us or the next owner of this. And we sure don't want to look at two contiguous buildings that go across the entire western edge of 15 Park.
Okay, thank you. Yeah, I think title to land, sometimes people can get it wrong. It's actually something you determine with land court records. However, and so, yeah, so if the selectmen, maybe they were right, but if they erred, that happens, so let's see here. As far as others with hands up, are there any others who I don't see anyone else? And if not, I think what we ought to do, and Vinnie, thank you, and the hearers also, we've got an extension. So we have, and we have now our next meeting, board members. I'm going to remove from the panel everyone except board members at this point, if I can figure out how to do that. Well, I don't know how to do that.
George,
Yes.
there's one more person with their hand up, Steve. Looks like
Steve.
yeah.
Okay, hang on, Steve. Okay, yep, Steve, okay.
Hi, George. Can you hear me?
Yes, I can.
This is
What's your last name, Steve?
this is Stephen Hirschberg from 4 Oakley Road.
Okay, thanks, Steve.
I just wanted to comment. I'm a little concerned about how this conversation and this case has evolved. Initially, my understanding was that it was focused on the extension, the stub that you referred to as being a paper road, and since it's a paper road, it's not really a road, and whether the setbacks apply. But suddenly listening to this conversation and listening to Vinnie O'Brien's comment that now the entire Oakley Road is in question. We've lived at 4 Oakley Road for over 26 years, so we've really benefited, and we value the service that the town has provided maintaining our road. And suddenly now, after 20 years, more than 20 years, that's all in doubt and in limbo. And I'm a little concerned about how this conversation has evolved.
No, I don't blame you. And in fact, yours is not the only road that has been accepted at town meeting, but where there was no subsequent deeding of the interest by the people on either side, or in the case of developers, the developer did not deed to the town, and so that has not occurred. If there's any comfort in this, I mean, I can't promise to go out and plow your street. I don't think the town would back away from that. If at some point our council feels, hey, this is an issue not only for Oakley, but really for lots of our roads in this situation, do we go back to town meeting and have another vote to accept, and then have the necessary recording? So that is, but I think at this stage, what Vinnie has said is simply, I think, a fact that title is not on the land court records in the name of the town. Laverne, you had your hand up, please.
Well, I think we're getting off point in many different directions, and it seems to me that we're here tonight to sort of make a determination on whether this is a corner lot or not.
Not
That's
tonight.
kind of,
No, we're
not,
getting,
well, not tonight, but that's,
getting
so
the
we're kind
facts.
of going all over the place with different things. Am I correct or not correct? I mean,
No, you are correct. What?
okay, we're
there
not
has
going to
been
decide that
concern-
tonight?
No, you've been concerned, there has been concern about the planning board process. The statements that Stubb is no different from the rest of Oakley. Taking title is important.
He believes it now.
Yeah, but I think here, Steve, do you want, but I think at this stage, I don't think we can really undo whatever the record is for that property. And we frankly, I don't think, we don't have the power, I don't believe, to start undoing town meeting votes. But let's have the board do it. There's also, and however the decision comes out, whoever is unhappy with it, there is an appeal right. But you've heard at least what this one member of the board thinks. Subject to maybe changing my mind to something else comes about. Okay, I think here, board members, what we ought to do is pick a date to meet again. And boy, I hate to ask, because I know we've got a big meeting on the 30th. And we could put this in behind that meeting on the 30th. We could also try to wrap this up, at least with a sense of the meeting vote later this month and not on the 30th. The 30th, we've got all the peer review reports coming in, lots of stuff for that 40B. If we did schedule a meeting for the week of the 21st, would that?
I think that's school vacation week, George. I think people are traveling. I think their deer is out.
Okay.
Yeah, that's right. Thank you.
Okay, then if we don't do it on the 30th, we could try to put this in as a later item on the agenda after Tisdale. I just don't know how much time that's going to take.
But George, why couldn't we go out to the first week in May if the Hears have agreed to?
Yeah, and in fact, let me just see. Vinny, what day did we go to for that extension
I believe you said the 13th.
of May?
I thought that's what you said. I'll take a
Oh,
look.
I think it's a little later. Let me just check. I can find out.
23rd, May 23rd. Appreciate not going that far though.
Okay. Yeah. I think we could meet during the week of May 5th and get this wrapped up in time for the 23rd to have a written decision.
Okay.
George, how are we going to utilize town council? I still feel like we need. My head is spinning. I just need someone to kind of help. From a town perspective.
Yeah.
I don't know whether we're going to get more counsel. We're gonna hire someone. I don't know.
Kristen's firm represents the town.
Okay.
Yeah. So she essentially, when she is working for us, she is for the town, and her position is to get us to the right answer, whatever it is.
I'm happy to meet with the board.
And if it's gray, we just need to know which is the darker gray, which side, because there is, this may be, there is a basis for difference of opinion on this legally.
And I'm happy to, if the board has specific legal questions, meet in executive session if need be, or draft a written opinion. I think you have a lot of written materials at this point, so I don't know how helpful that is, but if there are questions for executive session, that's possible as well.
Well, I think is this a matter where we can, it's not threatened litigation, it's not personnel, just for arriving at a decision. can we do this in executive session?
If you have a specific legal question about, as it relates to the application.
Okay, so could we with you, and the reason for executive session is, and quite frankly, I don't know if that, I mean, I don't mind the transparency of having everyone, but I would like not to have everyone chiming in again. I mean, that this would be a working session. Why don't we, let's discuss, let's set up the meeting and we can decide whether as part of that, we go into executive session. How do members look for the week of May 5th?
Fine.
Okay. How does Wednesday, May 7th, does that look okay?
Good for me.
Yeah, that works.
Great. Okay. That's good. Well, listen, I'll advertise that. So that's May 7th. And a portion of that meeting will be open to the public, and then we'll decide whether a portion should be an executive session or not with our counsel. I like the idea of being able to speak with our counsel, that way. Okay, so May 7th, that'll be it. I think we'll need a vote to continue the, may I have a motion to continue this hearing until Wednesday, May 7th at 7 p.m.
So moved.
Second.
Okay, and then all in favor with a roll call, please.
Laverne Lovell, yes.
Mike
Nadir,
Donovan, yes.
Thanks, Mike.
Nadir Ahmed, yes.
Nancy Green, yes.
And George Chimento, yes. Okay, so that's, boy, we're gonna have a busy spring. Okay, I think the next thing is we were going to review some minutes which I circulated earlier. Let me just see here. Hang on a minute.
Good night, everybody.
Hey,
Good night, Ben.
Cheers.
Good night.
Thanks, everyone. Good night.
Good
Good
night.
night.
Okay, these are the March 20th things, and hang on just a second. Okay. So
We see him.
So you've got that, and I think everyone was, I didn't hear any real concerns. So unless someone would like to add something to these, may I have a motion to approve them as submitted and a second?
So
I
moved.
make a motion to approve the minutes as presented.
Thank you.
Second.
So
right.
George, we haven't heard anything from the Tisdale group, right?
Hold on.
I have
Hey,
rumors
let's just
that,
take a vote on this, and then we'll.
oh, okay, go ahead,
So,
sorry.
okay, roll call vote, please, on the minutes.
Nancy Green approved.
Mike Donovan approved.
Nadir
Laverne
Ahmed.
Lovell approved, sorry.
Nadir Ahmed.
We have to start doing this alphabetically, you know? You start, you know what I mean?
You got it. That's right. And George Chimento approved. Okay, great. Now, yeah, I think on the agenda, we can just have general discussion. Since our last meeting where, Sean Reardon was extremely and with much appreciation, frank about what he needs.
Yeah, I read that today again, because there's a lot to read.
George, should we close the hearing? The other hearing? We close it?
Okay, yeah, I'm sorry. I thought we had actually done that one.
Did we?
Yeah, we
To the
did.
next session. but
Okay, I'm sorry. Yeah,
Oh, that's okay.
I just saw, like, I think Tom is still on the line. I see
Okay,
one of
well,
the,
yeah.
yeah.
Tom's welcome, but yeah, we're not gonna be discussing, because this meeting's open, so
Okay,
everyone's
good.
welcome to stay. But yeah, we're not discussing that matter now. Yeah, so, yeah, I think, I've heard nothing else at this point. But they, they've got marching orders on how to do this. And what I will do is just follow up. They're supposed to be dealing with each other. One thing I've heard nothing about is, meeting with the fire chief. Because that was one of the things on Sean's checklist, for the developer to do that. And what I will do is follow up. It helps if I follow up with the developer.
I think, George, that they're having great trouble trying to find water.
Oh, yeah.
I
No,
think it might be a moot point at this, just, I've heard that from somebody who lives at Tisdale, that, of course, they're all hoping that that's what happens, but,
well, yeah, and it's just,
if you don't
I
have
mean,
water, where are you gonna get water?
well, see, and that's where, and, legal counsel, in fact, let me just think here. Should we be talking about?
I was just about to jump in
No.
and say, I don't think this is on the agenda, so this
No.
is, beyond the
Okay.
scope of the
Oh,
meeting.
Yeah, I'm gonna blame Laverne. She always
Just
gets.
blame me. I always come up with things that are illegal.
Okay, but otherwise, hey, let me ask, one thing. You see, I've been sending you everything now to the board addresses and to the home addresses, everything, because you probably don't like to look at your board email every day. Am I correct?
No, I look at it every day now that I finally
Good for
figured it
you.
out.
Okay. I mean, what I'm thinking is, I think it's better for us if we only send things back and forth now to these Google emails that the town has, which are a pain in the neck. You can't send big files with them. I mean, it nearly electrocuted me when I tried to send Vinnie's memo to everyone to look at. But I think generally, if it's okay with you, I mean, if we could, what'll happen is if there is ever litigation against us, they're gonna ask to produce materials. So the more that you've got in your home email from the board, it'll be duplicative of what we send to the town, but it just could create more of a pig pile for discovery than we need to have. So it really would be best if we just limited it, and I've made it a point always that we do not deliberate on email. We've never done that, and we never will. So this is more just sending enclosures as I get these things, and I want you to look at them before a meeting. What I'd like to do, if it's okay, would be just to send them to you at your board address. But let me think about that also. When you get these things, do you then, for convenience, I mean, I store them all now on a shared drive for the board. We've gotten that active. That was never active before. This all used to be on Alan's computer. But that is also cumbersome. I mean, so if I send you something to your board address and you want to download it on your computer at home so you can read it, God, maybe it's, as I think of this for your convenience, if you are downloading things to read on your computer, I ought to send them to your home addresses too. And you just get them in two places.
Yes,
fine.
that would be
It's fine.
preferable.
Yeah.
What, Mike?
That would be preferable. I don't want to go on Google Drive.
Okay, well, listen, let's just do it. We'll just send, so you're gonna see these things and you'll just see stuff in your town mailbox that is
Yeah,
gonna be.
I never go there. Never.
That's
You know
not.
what? Google Drive is free and it's for a reason. You're vacuuming up all the information on everybody. So I refuse to go there.
It is such a step back when you're used to Outlook and Microsoft. But But it is popular, not just with our town. It seems that lots of governments and nonprofit organizations use Google, and it's because the price is right. You know, it is networking and storage that you don't have to really hire someone for. Okay, so I'll keep sending stuff to both of us, both the addresses. Is there anything else, or should we entertain a motion to adjourn?
So moved.
Second.
Okay, alphabetically, sound off.
Nadir Ahmed, aye.
Mike, aye.
Nancy Green, aye.
Laverne Lovell, aye.
George Chimento out of order. Also.
Sorry, George.
Okay. Hey, thanks very, very much.
Yeah.
And,
Thanks, Kristen. Yeah. See ya.
Okay.
Good night.
Thank
See you
you,
guys.
George.
Thank
Nice
you,
job.
Kristen.
Big job.
Hardest working board. Good to see you guys.
Okay. There we